Welcome all. I am presenting a paper on arbitration in town and country planning. Arbitration is a legal technique for dispute resolution outside the court, wherein the parties raising or having disputes refer it to one or more persons, which is generally agreed to accept the decision. Arbitration is the form of dispute settlement where the parties can avoid their disputes in public litigation without approaching the court of law. Any dispute or difference whatsoever arising between the parties relating to development issue of land use or building regulations and bylaws, construction or effect of the contract or the validity or the breach of thereof shall be settled by arbitration in accordance with the Town and Country Planning Act 1996. The purpose of development plan is implementation of development projects, town planning schemes, land pooling schemes, loss of land because of land reserved for specific purpose or influence zones, reconstitution of irregular plots, change of land use, spot zoning, special permission for high area fair under TDR rules, encroachment over public or private land or its regularization, etc., are covered under the disputes arbitration. Conflicting values require public officials to make tough choices. Too often, it seems land use disputes turn into lawsuits. Land use disputes often result into litigation. There are other ways to resolve conflicts. The lawsuit enters the judicial system through the court, and it may take years to receive final decision from the court or high court or the Supreme Court. Therefore, creation of a state land use planning court called State Land Use Planning Tribunal under the Town and Country Planning Act is the need of the hour on the lines of State Administrative Tribunal. Town planning schemes framed and published under the provisions of respective Town and Country Planning Act by the state, where the valuer may be required to either function as an administrator or town planning officer or represent his client, who may be either individual owner or the local planning authority. Further, the valuer has to have the knowledge of law on arbitration, and therefore is essential for a professional planning to have an expertise or knowledge in the following areas, namely property, both land and building, fragment property, insurance, etc., contract, including employment contract, if any, business or partnership disputes, family disputes, except divorce matters, construction activities of project, commercial recoveries, pending or outstanding. There are non-arbitral disputes also, such as matters of criminal nature, disputes relating to matrimonial relations, testamentary matters relating to the validity of a will, matters relating to trust for public purposes of charitable and religious nature, insolvency matters relating to the guardianship of a minor or lunatic, or any other execution proceedings. The cost of the development project is normally the minimum, and the developed plot itself will be a prime resource for the project. The town planning scheme has been provided with an inbuilt mechanism for arbitration. Conceptually, town planning scheme or land pooling scheme is a joint land development project undertaken by the landowners. In the case of tribunal consisting of more than one arbitrator, any decision of the tribunal shall be made by the majority of the members of the tribunal. Crisis may arise where there is no consensus between the members of the tribunal, and when the members of the tribunal take divergent views in such circumstances, the arbitration will fail. The parties may settle the matter during the arbitral proceedings either by mediation, conciliation, or by proceedings, and in such case the settlement will take the form of award after an agreement. The most significant finding in Indian towns and cities is the land belongs to many central and state agencies, including ministries and departments, farmers, individuals, trusts, societies, international organizations, etc. The futuristic development plan has to be integrated with the proposals of the government and also the society for better purpose. To dovetail all those such proposals in the development plan for enforcement or implementation, and having no freedom to any agency or to deviate from the plan which is not within the framework of the land use after its notification. No authority, whether central or state, private or public sector establishments, can function in isolation, and therefore they have to abide the rules and or go ahead on their own with the proposal within their premises without seeking clearance or approval from the master plan or development plan land use controlling authority. Courts of some kind are also ultimately necessary to resolve the remaining disputes. The disputes cropping up due to wrong unilateral decisions by the defaulting agencies will lead to chaotic conditions in the urbanization process, and hence the increase in arbitration cases in urban planning and development can be seen. Respective state governments has to look into this important area and enact the adequate safeguard through strengthening the existing Town and Country Planning Act appropriately, and also by spreading awareness among the land-owning agencies to approach the Land Use Planning Authority before taking up the development projects for implementation instead of falling into litigation. Now, the addressing the land use conflicts in the growth management. Conflicts over the land use are many and they are increasing. Some are inevitable, but needlessly waste their limited resource in both public and private sectors. Moreover, litigation may resolve issues between two parties but produce solutions that they are less than optimal for the larger community. The important point is that these states have to find the ways to prevent much of the conflict by creating forums like State Land Use Planning Tribunal, where the common land use goals and strategies can be agreed to by the key players at an early planning stage rather than waiting for the difference to be resolved in the legal court. Lately, most of the ministries and their undertakings are autonomous bodies, private establishments which hold huge areas of land resource want to develop for infrastructure, housing in the name of operation purpose, commercialization of potential surplus land, and also exploit for future viable projects. Such projects can also go ahead if these have been incorporated in the notified statutory plan document after studying the proposals in detail from ecology and environmental angle. Justification for projected demand, including the future requirements, etc. The worldwide practice followed in most of the countries also applies to India in order to maintain an integrated development of any city or region in looking into FDI flowing in major cities in the country. It requires, moreover, the assent and cooperation of many important actors. Group processes, especially those that aim towards consensus building and seeking common ground rather than following adversarial procedures, can go a long way towards establishing a framework to support the overall development. It is useful to think of primary functions, namely to provide a forum where the participants can develop a shared meaning and the issues and negotiate their differences with the state authority. Not all the issues will be resolved in such forums, and hence courts are ultimately necessary to resolve those remaining disputes if it remains unresolved. With increasing urbanization trends in Indian cities and mounting pressure on urban land because of rising land value, the land owning agencies are going ahead to encash the available land resources for potential purposes and generate economy without seeking approval from the Land Use Planning and Development Authority before taking up the project implementation. Such activities seriously hamper or affect the overall development of the city and likely to create many more problems of urban management. The disputes cropping up due to wrong unilateral decisions by the defaulting agencies will lead to chaotic conditions in urbanization process. The respective state government has to look into the important area and enact the adequate safeguards through strengthening the existing Town and Country Planning Act appropriately, and also spread awareness among the landowning agencies to approach the Land Use Planning Authority before taking up the development projects for implementation instead of falling into litigation. Thank you very much for kind hearing.